SJC-10658, Commonwealth v. Frank DiBenedetto.
Thank you.
You got in the bus?
Ms. Sibison, welcome.
Good morning, Your Honor.
Welcome back.
May it please the court. I'm Wendy Sibison, here with Dennis Shedd, representing Frank DiBenedetto, in his motion to reinstate his 2011 appeal in DiBenedetto 3. That appeal was heard based on a gatekeeper finding that his newly discovered evidence of DNA testing was new and substantial. This court wasn't able to reach that question. It needed further findings. It vacated the denial of his motion for new trial. New findings were made. No evidentiary hearing was held. When we came back to a single justice and asked to reinstate our appeal, the gate was closed. So I'm here to ask this court to hear that appeal. And I talk about the procedural question, which requires essentially an interpretation of Section 33E, and I hope to spend some time on the merits.
Okay.
This case raises important questions about how this court treats 33E defendants who are convicted solely on eyewitness testimony, corroborated solely by physical evidence, later invalidated by DNA testing. That this type of scenario underlies so many wrongful convictions can't be understated. In the first 250 cases of people exonerated in this country, 78% were by eyewitness misidentification, and 58% were based on forensic evidence later proven invalid, just like in this case. So that's the backdrop to why I'm here. In terms of the procedural question before this court, it requires just a look at Section 33E and a few of the cases talking about 33E. 33E allows a defendant convicted of first-degree murder after rescript to bring his appeal from the denial of a motion for new trial to this court if a single justice finds the issue in his motion to be both new and substantial. The purpose of the statute is to screen out duplicative and frivolous claims. And the justification for it is that the defendant has already had plenary review by this court that nobody else gets. Well, let's start with the fact my client hasn't had plenary review. This court hasn't had the opportunity to decide his case based on the newly discovered evidence. And more to the point, the statute says one gatekeeper entitles him to a decision on the merits by this court. It is a statutory right, and my client hasn't had it yet.
I gather your first argument is that the gatekeeper already found it to be new and substantial, and
Yes,
that
Your Honor.
gatekeeper was Justice Cordy.
Yes, Your Honor.
And the issue that was new and substantial was whether or not this newly discovered evidence of the DNA raises a substantial, at this point, risk of a miscarriage of justice.
Yes, Your Honor.
And so you say that's the issue, and now we have Judge Mulligan's findings
Yes.
that it didn't, he wasn't using new and substantial, but it wasn't a warrant for new trial, and so our job, so I think your point in terms of the 33E is we are now in a situation where the court was back in, whatever, 98?
2011.
No. Oh. I guess I was thinking I'm trying to get it. It seems to me your point has got. Okay, yeah, all right, fair enough.
Well,
One gatekeeper, Justice Cordy, found the question new and substantial. It's still as substantial as it ever was. Nothing has changed
Right.
that, and it's still new.
But one way to look at this is we had an option at the previous hearing.
Yes, Your Honor.
And that was to either remand it for findings or to do what we did, vacate it and
Yes.
then remand the case.
Yes.
And they're essentially one and the same thing for purposes of what you're arguing. We don't even need to deal with Section 33E. This case is it remains an open case.
Well, I would agree with Your Honor.
That's your point.
It is my point.
Yep.
It's not a new case.
Because we never did the
You never
substantive
reached
review.
the merits,
Yep.
which the statute entitles my client for this court to do. And this court is not, in my experience, a court that shrinks from reaching cases on the merits. And just to wrap up the procedural argument, any other construction of 33E allowing a second single justice to slam the gate before a defendant has reached a decision, before this court has reached a decision on the merits, would strip the statute of its salutary purpose.
But you would agree, right, that
Yes.
if Justice Cordy, back in whenever he did that, said, I don't think it's new and substantial,
Right.
you wouldn't be here.
I would not be here. We'd be all done.
Okay.
All right, let's focus on,
Yes. So,
help me to understand how one looks at the substantial risk as to whether the jury would have reached a different
sure.
conclusion.
So let's just, oh, I'm sorry.
I guess the question really is this. You can argue this jury had the DNA as an affirmative plus, that this was corroboration of the eyewitness testimony because there was blood found on the sneakers, and that is consistent with the view that he was near blood. And now you say, well, that would be now an affirmative minus, because now it would likely be offered by the defense to show that whatever there was not the blood of either of the victims, and if he had leaned down to where he had leaned down, you would have expected there to be blood. So that's where we are.
Yes, Your Honor.
But the Commonwealth would say, well, at a new trial, if you had done that, the Commonwealth would have offered various ways, which Judge Mulligan goes into detail with, to say that's really, that the absence of blood is really no big deal, that's not. Do we look at it in terms of the second jury, in
No.
terms of what the second jury would look at, or do we look at it in terms of what the first jury
I
actually
understand
did?
your question. The test concerns whether this evidence, had it been presented at trial, would have had a substantial impact on the jury's deliberations. The jury that my client had, not some future jury and some other trial with different evidence. So the way the court always looks at these cases, and it has in Cowles, and it has in Sullivan, and it has in Cameron, looks at the trial the defendant had, that there was one key linchpin witness corroborated by a single piece of physical evidence that later was eliminated by DNA testing.
But the Commonwealth would say, this case has been reviewed 3 times, twice by the SJC and once by the First Circuit Court of Appeals. And in each of those 3 prior decisions, there were an observation had been made that this blood evidence that was introduced at the trial was really not very persuasive at all, notwithstanding what the prosecutor argued. What do you say about that?
I'd be glad to answer that. No court so far, except for this court in DiBenedetto 3 that acknowledged that argument was forceful, has actually looked at the impact that that argument, the way the prosecutor used this, maybe to lawyers and judges, minimal evidence, but the way the prosecutor used it so powerfully in her argument. And that's a principal problem with the Superior Court's findings here. The Superior Court never assesses the power of that argument in the real trial that happened, that my client was convicted at. How the jury would have been affected by that evidence and the way the prosecutor used it. Look, 3 out of 11 days of trial were devoted to the sneakers and the blood. That's pretty much at a criminal trial. And of the prosecutor's closing, she spent 32 pages talking about identification. Over 5 of those pages, and it was her wrap-up to her ID argument, the whole case was about ID, the last thing they heard from her about identification was about the sneakers and the blood and how it corroborated her identifying witnesses. At the risk of boring this court, I'm going to read those crucial lines because they couldn't have been delivered if the DNA evidence had been introduced at this trial. So if this court concludes that the
probably they
DNA
wouldn't
evidence wouldn't have had any impact on the jury, it has to also conclude that this argument, if I can find it, would also have had no impact on the jury
I think it's in your brief.
But I guess what's in the brief?
because it couldn't have been given.
Okay.
And here's what
we've all read them, but I guess what I'm having trouble getting a candle on is if the evidence had been known that closing argument would never have been made.
Yes, That's what I'm saying.
And
And it's the closing
But a
argument.
different closing argument would have been made. Different closing argument would have been, I know the defense offers the fact that it's not the blood of the victim.
Well-
It's just no big deal. It could have, there are 1,000 reasons why that could be the case. You should give almost no weight to it.
That argument could have been given, but that argument would have been based on zero evidence. There was no evidence, unlike one of these other DNA cases I met, that the defendant threw his sneakers away. There was evidence there that he threw his sneakers away. None here. There was no evidence that he tried, neither of the eyewitnesses said the guy was standing way back while he shot him so he wouldn't get blood on his sneakers. That was another speculative theory that the judge came up with.
Did you have, at trial, was there evidence, I should remember this, but I don't. Was there evidence about what happened in the DA's office that Mr. Schindler, do I have to say
Yes.
that? That's the first time he saw the sneakers and all, was all that introduced at
Yes,
trial?
yes, it was.
So was that the defense argument that this ID by Joseph Schindler was just forget it?
Well-
I'm just trying to remember.
Well, that he improved, the argument was that he improved his identification several years later by adding that they were high-top, dirty, white Nikes. Before, he just said they were, I think, dirty sneakers. And then a few years later, he sees them in the prosecutor's office, but where, by the way, he was,
Did he ever mention the swoosh before seeing them?
no, nope. They turned into Nike red swoosh. 88 feet at night. He
Well, the
claims
judge-
to have seen a red swoosh.
But the judge made findings that, that the area where Schindler had seen the
Yes.
defendant walking down some stairs or up some stairs was
Yes.
well lit, and that was corroborated by the testimony of a police
I
officer.
think that, I don't think there's a problem with that area being well lit. The problem, in terms of reliability of eyewitness identification, is that he was, in fact, no matter what anybody else says, the record bears this out and the court will look at it, his perch was 88 feet from that spot, and he agreed that the only time he had to see the defendant's face from that spot was 3 to 5 seconds. So
So we have 3 to 5 seconds he saw his face, and 3 to 5 minutes is the entire
watching
interaction?
the whole business. But he agreed on cross, okay, it was only 3 to 5 seconds from that spot, and he claimed that it was 50 feet, but a police witness said, no, it was 88, and Schindler said, I'll go with the measurement, not by my memory. So it was far.
Yeah, but he also identified the defendant in a packed courtroom where the defendant was in the general.
That was
General
after the
population.
lineup, which was after he read a Globe article that he admitted had a photograph of my client and Mr. Tanzo, the same people he identified 3
He
days
didn't,
later.
did he say he didn't read it until after his secretary or somebody cut out the photo?
He says that he had instructed, he didn't say he didn't read it until after, he said he'd instructed his secretary and his partner to cut out the photo. Do I have it here? No, I do not. It's a big photo.
But
It's at
did
the
he
end
s-
of the appendix.
Did he say he saw the photo?
No, he says he read the article, but he'd instructed these people to cut them out, and we called them as witnesses. And the secretary was scared of that, but apparently she was crying, she was so scared to be called as a witness. She said, I don't remember anything like that. And the partner said, I don't think so, no, it didn't happen. Now, if I were a secretary or a partner of a lawyer who saw a heinous murder and was a principal murder, I think I'd remember if he told me to cut out photos. But the judge found him credible, but I'm just saying.
And aren't you stuck with that?
No, here's why I'm not stuck with it. Because, as I said earlier, the judge may have found these two people, Schindler and Starella combined together, credible. But what he doesn't grapple with is the relationship between that forensic evidence and the way the prosecutor used it to bolster their credibility. I mean, whether the judge found this man credible or not, he was heavily cross-examined. He didn't, the first time the police interviewed him, he says, I don't think I can interview anyone. And then his identification got better and better. He added height, which was wrong. Then the Globe article came out. Then he was shown the lineup. And that's where he identified DiBenedetto and Tanzo, who were both in the photograph. So he was cross-examined. The judge treats these two pieces of evidence as if they're in separate boxes, the identification and the forensic evidence. But the way the prosecutor used that forensic evidence, ending up with two witnesses, each independently corroborated, the one piece of real evidence that we have, that the one time these sneakers were in the presence of blood is as Frank DiBenedetto blasted into the body of Frank Ciuccolo. That was the last thing the jurors heard on identification from this prosecutor.
Was the evidence,
So, yes,
You finish.
these cases, the Innocence Project has wrote very eloquently and learnedly about this. These cases, based only on eyewitness testimony and bolstered only by later discredited forensic evidence, are the template for wrongful convictions. And this court has recognized that repeatedly in Cowles, in Sullivan, in Cameron. This case is no different. The language from those cases could be plugged right into this case. The sole piece of physical evidence supporting the Commonwealth's linchpin witness has now been invalidated. Plus, in this case, that evidence could be used to exculpate DiBenedetto. Schindler said, "I saw that man wearing those sneakers exactly like that," and we go, fine. Those sneakers,
Well, did Schindler say, "I saw him wearing those sneakers," or did he say, "I saw him wearing sneakers that were similar"?
similar, and the prosecutor turned that into it was those sneakers. She took that inference and used it in closing argument as if the evidence had been, those are the sneakers, and that's what she says repeatedly, those sneakers. That's how we knew those sneakers were in the presence of blood. So, and earlier in her closing, she notes that Schindler identified those sneakers. She moved it a little. It was a fair inference. She can argue the inferences, but the jury heard those inferences if they were fact.
I'm sorry, this is a little off, but Tanzo was separately tried, right?
Separate trial.
And was there some difference in the evidence? Because he was found not guilty, right?
That's right.
Was there some difference in the evidence?
I'm going to speak, and I hope I'm right about this, and I'll correct myself after if I'm right.
If you're
Schindler
wrong.
identified Tanzo just as forcefully as he identified DiBenedetto. So did Starella, except for one of Starella's many stories. In one of his 5 versions, he had put himself instead of Tanzo. Plus, no bloody sneakers. So, without the bloody sneakers, and with Schindler's powerful identification of Tanzo, the jury still acquitted him. So, I think that's an accurate
So there were
summary.
no bloody sneakers in, because obviously they're DiBenedetto's.
Sneakers didn't come in against Tanzo.
Okay.
They were tried separately. That's right.
So it's not
But-
the same jury, it's a different jury.
Yeah, it's a
And a
different
different
jury.
jury.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. We're asking the Court today to follow the directive of 33E and this Court's multitude of case law that says that a decision of the single justice denying leave to appeal is final and unreviewable. Because Justice Mulligan issued new findings in 2012 on the motion for a new trial, on the defendant's motion for new trial, the defendant was required to go back through the gatekeeper process.
What if we had retained jurisdiction and remanded the case for further findings?
I think that would be a different situation. This court certainly knows how to do that. I've cited to some examples in my brief of when the court has specifically done that, even on a gatekeeper petition, which was Commonwealth versus Mazza. The fact that the court didn't do that, that it vacated the decision, that it remanded the case and issued a rescript with the direction that Justice Mulligan issue new findings, says
But weren't we fully expecting to get this case back? We didn't have the tools to resolve the issue the first time around. We sent it back for findings, and wasn't everybody's expectation that it was going to come back up and we were going to make the decision on a better record?
I would suggest no for a couple of reasons. The first is the very clear indication of the 2011 opinion from this court, which vacated the decision, didn't ask for more findings, but vacated the decision, remanded the case, and issued the rescript with the anticipation that Justice Mulligan, as the trial judge, the judge who sat through the trial, who watched the witnesses and could make credibility determinations in his role as a trial judge, would make findings that would resolve the issue, that would resolve the issue such that the single justice would then be able to determine whether or not the defendant's motion presented a new and substantial issue. The fact that the judge made the findings in 2011 necessarily cast the defendant's motion in a light different than what was before Justice Cordy in 2009 and before this court in 2011.
Why is that? I mean, well, first of all, one of the purposes on remand was to give the Commonwealth the opportunity to offer evidence that said DNA could not remain for 18 years, so its absence means nothing, or that we're not at all convinced that the defense expert is credible in saying that the DNA of the victims can be eliminated. Did the Commonwealth offer any evidence on those points?
It did not, Your Honor.
Okay, so the Commonwealth didn't do what they were invited to do.
There was no evidentiary hearing, correct?
There was no evidentiary hearing.
Okay, so if it was new, and if the issue of whether or not the DNA made a difference, the newly discovered DNA results made a difference, was new and substantial when Justice Cordy says it was, why was it no longer new and substantial when it reached Justice Lank?
Because in DiBenedetto 3, this court invited Justice Mulligan, or one of the reasons that the court vacated the decision of Justice Mulligan in DiBenedetto 3 was because he didn't make findings as to the exculpatory value of the sneakers. He did that on remand when he made further findings on that particular point as the trial judge who sat through the trial. Because he made those findings and because he expanded his findings as to the evidence that the Commonwealth did put in, the testimony of Schindler, the testimony of Starella, and his findings that the DNA evidence would not have been exculpatory, the issue necessarily had to go back before the single justice. So the single justice could determine whether or not the defendant's motion, in light of the 2012 findings, presented a new and substantial issue.
Let me get at this another way. The allowance of a gatekeeper petition equals hearing on the merits, right? On a hearing on the merits of the claim that there's a substantial issue, hearing on the merits by this court.
I would agree
Right.
with that, yes.
Okay, where is that? Where did that happen in this case after Justice Cordy allowed the petition? Where do we find a decision on the merits of that petition in this record?
I first want to qualify my answer by saying, of course, if it's going to review the merits, it would have to be an issue that was not presented on plenary review. But in this case, in this decision, the court reviewed Judge Mulligan's decision, and the reason that it found error in Judge Mulligan's decision was precisely because he did not evaluate the exculpatory value of the sneakers as independent exculpatory evidence.
Okay.
That was the decision.
So wouldn't that mean that this court should decide as the full court whether or not Judge Mulligan's second decision was meritorious?
No.
That has not happened here.
No, because his findings, because his findings, let me back up for a second. This court, as far as the exculpatory value of the sneakers goes, that issue was not before the court because he hadn't made that finding yet. Now, it's gone back down before him. He has made findings on that issue, findings that were not before this court and findings that were not before Justice Cordy in 2009. Those findings could take care of the issue of whether or not this was new and substantial evidence. That is why Justice Lank had to review the petition as a single justice to determine whether or not Judge Mulligan's findings as to the independent exculpatory value of this newly discovered DNA evidence was new and substantial.
Well, this would corrupt the whole understanding of review of a gatekeeper petition if it could somehow be cut short through whatever procedural mechanism or whatever procedural inadequacy that's identified if we send the case back, but we still haven't given the defendant what he's entitled to under 33E. I don't care how you look at it. The full court has not decided.
Respectfully, Your Honor, I disagree because of the fact that there is now a different credibility finding by Justice Mulligan in 2012 that was not before the court in 2009.
Okay, but it's not two different things. It's the same case, and it comes out of the same issue.
I agree,
right?
Your Honor. Maybe an example would illustrate my point better. Let's say, for example, that we have a defendant, who's convicted of first-degree murder, and he's had his direct appeal. He files a motion for new trial based on newly discovered evidence. That newly discovered evidence is a third-party culprit, and to support his motion, he has an affidavit of a person who allegedly hears the third party make something that could be tantamount to an admission. In one scenario, the judge credits that affidavit, but he says, I don't think it would have cast real doubt on the decision because it wouldn't have been a real factor in the jury's deliberations. That could very well give rise to a new and substantial issue that a single justice could allow this court here, the full panel of this court. On the other hand, in scenario 2, if the judge flatly discredits that affidavit, either on its face or after an evidentiary hearing, then that's two entirely different situations for the single justice. In 2009, Justice Cordy didn't have findings as to the independent exculpatory value of the sneakers. In 2012, Justice Lenk did. They are two separate issues. And because that issue wasn't before, that finding wasn't before the court in 2009, the issue now is a new one that has to go back through the gatekeeper process.
Okay, let's turn to what would happen if we were to reach the merits. And I'm going to ask you a question similar to what I asked Ms. Sibison. How do we look at this? Do we look at it from the point of view of whether or not the jury which decided this case may have been influenced in finding the DNA to be corroborative of the eyewitness testimony and saying, well, they wouldn't have been able to have that. In fact, they would have had to diminish its importance. Do we look at it from the eyes of that jury, or do we look at it from the eyes of the fact that the case would have been tried very differently? Nobody would have made the argument that it corroborates, that the Commonwealth would have been arguing it's no big deal, he could have had different sneakers, 1,000 different things could have happened. How do we look at it?
I think you have to look at it in the second scenario Your Honor proposed, which is that we can't look at this in a vacuum. The defendant has indicated in a motion for new trial that if this DNA evidence had been available, they would have sought to admit it as exculpatory evidence. We have to look necessarily, and Judge Mulligan would have to look necessarily, as to the impact that would have had on the jury. Certainly, maybe the prosecutor wouldn't have made the closing argument that she did if that DNA evidence had been admitted, and certainly.
Well, I mean, I hope not.
Well.
Did just remind me.
Yes.
When it went back to Judge Mulligan in 2011, was the argument made that quite apart from whether this allegedly exculpatory evidence would have had an influence, the fact that the prosecutor couldn't have made the argument she made, was that put before him?
Yes, it was. And he decided, as this court has twice, and as the First Circuit Court of Appeals has decided, that this newly discovered, the phenolphthalein test, the presumptive positive blood test, was marginal evidence, nominal evidence that would be only marginalized further by the fact that this new DNA evidence undercuts it.
Well, we did say, and so did the First Circuit Court of Appeals, that it was essentially marginal evidence.
That's correct.
But how do we know that that's the impact that the evidence had on the jury, especially where the prosecutor argued, as Attorney Sibison said, very forcefully? And it was the culmination of her argument.
Well, it was the culmination of her argument, but it was also the culmination of the defense attorney's arguments. And I would ask the court to go back and review the defense attorney's arguments and their treatment of this evidence, which they very forcefully and very skillfully used as suggestion to the jury that showed that the Commonwealth was so desperate that they had to bring in this sneaker evidence at the 12th hour to be able to corroborate their witnesses. And they also used it as evidence of absence, I would argue to this court, that they put before the jury the fact that because there was no blood on the sneakers, it was just another piece of missing evidence consistent with their argument, the fact that Schindler and Storella were incredible witnesses, to argue to the jury that the Commonwealth had not proven its case against the defendants here.
If we are to look at this, are we, in your view, entitled to look at Schindler, quite apart from that point, but with respect to the eyewitness committee's report and in other words, the subsequent law about? questions about eyewitness testimony?
My answer to Your Honor's question is, I don't think it should, but ultimately, I don't think it matters, because the report of Mr. Somers, who's submitted a lengthy, particularized report as to this case to Judge Mulligan, that report was before Judge Mulligan, and Judge Mulligan indicated in his decision, his 2012 decision, that he gave it very careful review, that he was well aware of the problem of eyewitness identifications, but that this case did not fall into the case where it was a troubling eyewitness identification. Because of the fact that Schindler's identification was corroborated by Storella in many respects for all of Storella's credibility problems, the fact that Judge Mulligan, as the trial judge, sat through the trial and watched Schindler testify, that finding is entitled to deference because he was the trial judge. He was the person who was there. He saw the witnesses testify. He saw Schindler identify the defendant. And the fact that, well, again, and the fact that he knew that this was an issue, but because in his role as a trial judge, the trial judge in this case, he found that this was not a case where there was a problem with the identification. And I'd point out, this case is not like Mims and Cowles, not like Sullivan, not like Cameron. In each of those cases, there was one eyewitness, and in each of those cases, that witness had credibility issues. And the forensic evidence was the key evidence that corroborated that witness's testimony. Here, the two pieces of key evidence were Schindler's identification, his unshakable identification, as Judge Mulligan found, and his the corroboration of the identification by Storella.
When was Schindler in the DA's office? I mean, in
Your Honor,
relation to this trial, the trial that Judge Mulligan did?
My recollection is that it was in the mid-'80s, but I'm not certain on that point. I also want to make a couple additional points in response to my sister's argument, which is that Schindler didn't identify the defendant or have a clear view of the defendant for 3 to 5 seconds. He saw the defendant stop at the top of the third stairwell for 3 to 5 seconds. He had a full frontal view of the defendant as the defendant came down stairwell 2 and walked down the long pathway and approached to stairwell 3. And he testified that was about 30 seconds, in addition to the times that he saw the left profile of the defendant as he was coming down the stairs and leaving the scene. So that 3 to 5 second notation is a bit misleading.
Okay, thank you.
Thank you.
And we'll take our morning break.